You're all very welcome to Blackhall Place. There's a lot of familiar faces in the room, but for those who I haven't met, my name is Mark Garrett. I'm the Director General here in the Law Society. You're all very welcome. We're delighted to host this event here this morning with the Central Bank. My role is very simple, really. It's just to facilitate the conversation and talk to you about some boring logistics as well. So some housekeeping just to get going at the start. The obvious about your mobile phones, please turn them off or have them on silent to respect the speakers and the other contributors. That'd be great. If you're going to use social media, please tag at LawSoc Ireland account and the Central Bank _.ie account as well. And just obviously for a brief safety announcement again about be conscious of the exits, both obviously the door you came through and obviously the exit door here. Hopefully we don't require them at any point. But also, I think, logistically, I just want to talk you through how we intend to run the event this morning. So we'll have a couple of speakers to start, and just some welcoming remarks from the President of the Law Society, Maura Derivan, and followed by opening remarks from Derville Rowland, the Deputy Governor of the Central Bank. And following those, we'll open it up for a Q&A session, and we'll have, just great to have such a great panel, where Derville will join us on the panel, but also with their Central Bank colleagues, Gina Fitzgerald and Peter Gallagher. So please have your questions ready, and we'll go through the logistics of the Q&A when we get round to that piece as well. The other piece of logistics, just to be familiar with as well, is that the early part of the session will be recorded just to share the insight with others who aren't able to be here this morning. But we will stop the recording when the Q&A session starts, because obviously we're not looking to identify people who are asking the questions and all of that sort of interaction. So the recording will stop at that point when we hand over to the audience for the Q&A. So we'll let you know again when that all kicks off. All right. So all that remains really is to get started, and I think just like to welcome to the podium our first speaker, the President of the Law Society, Maura Derivan. Thank
you. Good morning all. My name is Maura Derivan. I am the 152nd President of the Law Society of Ireland and the 6th woman President. I hail from Dublin, having trained in Mason, Hayes and Curran, and I see some of my compadres there, and moved on then to be what they termed those days as a junior partner. I know there's all sorts of partners now, but a junior partner in Open Franks, before love in the form of a tall, dark, handsome solicitor took me to Tipperary. So I've had both sides of experience in large firms, and particularly I know all of the pressures in relation to regulation and the financial sector regarding both in larger firms and indeed in smaller firms. I am very pleased to welcome you all to the Law Society this morning. I welcome particularly Derville Rowland of the Central Bank Deputy General, and also our panellists, Gina Fitzgerald and Peter Gallagher. We're all delighted that you are joining us here in Blackhall Place. On behalf of the Law Society and the solicitors' profession, I'd like to thank the Central Bank for the opportunity to participate in their consultation on the Individual Accountability Framework collaborative consultation with stakeholders, provides that will ultimately benefit consumers, the public, who are both legal and financial professions serve, and the economy. And in particular, I just want to say that we were all aware of the movement in Ireland for Law, which is growing in strength and enthusiasm, and very much has the backing of government. And there's a lot of work being done out there to promote Ireland as a place to do international business. And so regulation, and as Derville Rowland has told us, illumination on the regulation rather than instruction, is very important for us to bring forward Ireland as a place, a safe place, a regulated place to do business, and the place in Europe to do that business. I'm going to speak a little bit off script now to tell you that today is an extremely historic day for all women solicitors. It was this day, 100 years ago, that the first woman solicitor, was admitted to the rolls, followed a short time after by another woman solicitor who obtained a practicing cert. And they were Mary Dorothea Hernan and Helena Early. And it was on this day, exactly 100 years ago. So let's just step back a little bit into the mists of time, and I wonder if what Derville and Gina and I, and all of you ladies, might have been doing 100 years ago. If fortune had smiled on us, we may be well sitting in our parlours wondering what cook might have got together. Was the fish come in for that dinner party we were doing later on that evening? On the other hand, if fortune did not smile on us, we may well have had to get up at, even as early as we get up now, 5:30 or 6, to make sure that that dinner party did work. However, those two ladies went out there and took up a shovel and made a path. That path became a laneway. Through the next 100 years, that laneway became a highway. And the previous presidents, and I see our immediate past president, most welcome, Michelle Ní here of Burnwallace, here today, we walked on that highway. And it is for the future, and you younger women solicitors here, to make that highway into a motorway so that we can all reach the equality that we deserve and bring Ireland even further as that modern, well-regulated, business-type country that we can be and are indeed so proud of. The aim of the joint Law Society Central Bank event is to outline the approach that will be implemented of key aspects of the new framework. Crucially, you will have opportunities to put questions to our panel about the new framework, and I urge you to take advantage of that chance and also to provide feedback based on your professional experience and to seek clarity on the core aspects of the framework. Enhanced governance, performance and accountability are values shared by our two professions. The legal and financial sectors in Ireland are highly regulated, or will we say illuminated on regulation, which is as it should be, because public confidence and trust is the cornerstone systems of our society and are integral to a functioning and independent democracy. Where there are gaps, we must work to address these for the public benefit. So engaging together here this morning, I would encourage you to keep in mind how through this new consultation we can best work in the public interest. I would like to say to you that we have, as I said, set up this wonderful consultation here today, and I urge you to make the most of the time and the expertise that we have, and I hope you enjoy this morning. Thank you.
Thank you, Maura, and for provide some opening remarks, I'm delighted to introduce the Deputy Governor of the Central Bank, Derville Rowland. Thank you.
Good morning, everybody. It's a pleasure to be with you here to discuss the Central Bank's consultation on key aspects of the individual accountability framework. And I'm really grateful to the Law Society and its members for kindly hosting us today. At its core, financial regulation is about supporting positive outcomes. It is about protecting consumers and investors and ultimately contributing to the economic well-being of the community as a whole. The regulatory expert, Professor Malcolm Sparrow, who practices in Harvard Kennedy School, notes that the challenge for all regulators is the aim of reducing harm on the one hand and respecting the traditional regulatory values of fairness, consistency, proportionality and predictability on the other. So, since day one in framing the individual accountability framework, this challenge has been at the core of our thinking. The purpose of the individual accountability framework is to promote sound governance throughout the regulated financial services sector. And the framework and its ethos is very much in keeping with the key themes of the central bank strategy, namely safeguarding, being future-focused, transforming, and doing that in a manner that is open and, I hope, engaged. So, in the spirit of being an open and engaged regulator, We want to hear from as wide a group of stakeholders as possible who are interested in the topic of the individual accountability framework at the point before it has been settled. So that means we want to hear from industry representatives, some I see here today. We want to hear from staff of the regulated businesses who will have, we hope, the benefit of this framework. We want industry insights. We want members of the legal community and all of the professional advisors who serve the needs of the firms and businesses who provide financial services to consumers, investors at home, and increasingly internationally in this jurisdiction. So I'm delighted that so many of you here this morning, and I really do underscore the desire to hear your views today and during the course of the consultation. Perhaps today you'll share views, you'll ask questions. Ultimately, we'd really like to receive your submissions. And actually, I'll detail some of our proposed approaches that we have already set out in our consultation paper. Now, I want to start from the mindset. Our starting point is that we're very clearly of the view that most firms and individuals who work in them aspire to high standards. And that's why we have said and really believe that the majority of firms and staff will have nothing to be concerned about with the implementation and the operationalization of the individual accountability framework, because they're already operating to the principles that you would expect. But it's also true to say that there are times when those principles are not as clearly embedded in firms as they could be, or firms do lose their way and they don't achieve the outcomes that we would expect if those high standards were firmly embedded. That can cause reputational issues for the firm, for the sector, for the jurisdiction, for the economy, and it poses a risk to consumers and investors. So we think the IAF will drive important governance improvements and accountability in the sector that will be to the benefit of all. We have done a lot of work with our colleagues in the Department of Finance to progress these proposals, and on the 9th of March, the Individual Accountability Framework Bill of 2023 was enacted, and shortly thereafter we launched our 3-month consultation on the implementation, and included in the publication were draft regulations and guidance. So you probably all are already aware there are 4 key elements of the framework. A senior executive accountability regime, which is aimed to ensure clearer accountability by imposing obligations on the firms and senior individuals who are in scope, so that you can be very clear and at a glance see their responsibilities and where decision-making lies in a business. Conduct standards, which set out the standards of behaviour the central bank expect of firms and individuals working in them. There are enhancements contained in the legislation to the current fitness and probity regime, which addresses some of the limitations in the existing regime. And finally, enhancements to the administrative sanctions procedure, including key changes regarding enforcement ability to take action directly against individuals who commit breaches of their obligations, rather than having to demonstrate as a preliminary matter that they participated in firms' breaches. Of course, the Irish financial system serves not only Ireland, I've already said, but Europe and global economies. So if we get this right and implement it in a proportionate and high-quality manner, it will support Irish business to further fulfil their role of a trusted provider here and abroad. It will act as a protection to consumers and investors, and ultimately be a kite mark of quality for this jurisdiction. The IAF is aligned to our strategy, rooted in our own regulatory philosophy, whereby regulation should be forward-looking, connected, proportionate, predictable, transparent and agile. And we have considered the changing financial services landscape and the international developments in the area of individual accountability. We have noted the evidence of the effectiveness of similar regimes in other jurisdictions from the perspective of both the relevant regulators and the firms to whom such a regime applies. From the international experience, we believe the IAF will not just assist the central bank in its mission, but also firms in theirs, because a long-term outcome of a more trusted financial services sector is in everybody's interests. Now, while the IAF is designed to bring substantive benefits, we're conscious that there will also be costs associated with its introduction. But overall, we think it's important that the benefit outweighs the cost. And we carefully considered this aspect up front. But we also recognise the importance of ongoing review. And we note that the UK is doing precisely that with their regime that's been in place since 2016. So whilst the initial scope of CIR will be with regard to approximately 150 firms, the conduct standards and the enhanced fitness and probity regime, together with the administrative sanctions procedure, will apply to all regulated firms. In the context of firms within the scope of the CIR, there will inevitably be an increase, but we think a necessary and proportionate increase in the administrative burden during the initial implementation phase. And we also know it will take time for firms to prepare their statements of responsibilities and the management responsibilities map. But as firms become more familiar with the regime, as they implement it, we think that administrative burden will recede and the benefits will become more apparent. For the broader population of firms, there will be a requirement to notify and train individuals in respect of the conduct standards and to provide an annual confirmation in respect of the certification of CF's control functions, which include PCFs. Sorry, this is a lingo that people who work in financial services will be familiar with, pre-approval control functions. And that notification will be to the central bank. But as I've said, we think as this becomes more embedded as business as usual, that new way of doing business and the burden that that initially will take will recede and the benefits will become more pronounced. Best practice provides that new and significant regulatory frameworks, and we acknowledge that this is the case, should be reviewed after an initial period of operation. That's just good business. So accordingly, it will be our intention to prepare and publish a report on the operation of the new framework based on the first 3 years of operation. In our review, we will consider the functioning of the framework, how the benefits and the costs are being realised in practice, and whether any tweaks or changes are merited at that stage. So turning now to some specific aspects, it's proposed that CIR will initially apply to a defined range of regulated firms. I've referenced the number of 150. That's namely credit institutions, excluding credit unions, certain insurance undertakings and investment firms, and incoming third country branches of these firms. Taking into account nature, scale and complexity, it's intended to apply a proportionate approach to low impact rated in-scope investment firms and incoming third country branches. Again, apologies for central bank speak. That's related to the PRISM impact, the way we assess the regulatory intensity of the way we look at firms and deploy resources to scrutiny. In this regard, a reduced number of prescribed responsibilities are applicable to such firms. All other elements of CIR will apply, including statements of responsibilities and management responsibilities map. The central bank will have a power via regulation to roll out CIR to other sectors in due course. It is our intention to increase the scope of application of CIR over time, with lessons from the initial rollout to be incorporated as we go to inform our view of the phasing of that and the timing of that. In the meantime, our view is that there is much in the spirit of CIR that firms who are not initially within scope would be well advised to recognise and be early adopters, because it is only aligning with good governance. We have designed the framework such that for consistency and coherency reasons, the roles to which SEER applies to the in-scope firms align with the existing fitness and probity regime and the existing PCF roles. So that will make life simpler for firms to think about roles, responsibilities, the PCF system and SEER fit on top of each other. So, as is the case under the fitness and probity regime, firms will not be required to create new roles. Therefore, it will bring clarity, but SEER will not be expected to alter the existing governance and structures of a well-run firm. There are two main types of responsibilities imposed under the framework. Firstly, inherent responsibilities. These are the responsibilities which automatically align to any given pre-approval control function role, PCF role, at the in-scope firms. Our proposed description of such inherent responsibilities are set out in the draft SEER regulation. And secondly, prescribed responsibilities. These comprise a list of responsibilities which it is proposed that each firm that is in scope must allocate amongst the individuals who hold PCF roles in that firm. Again, our proposed list of prescribed responsibilities is set out in the draft SEER regulation. Now, while firms must allocate all applicable prescribed responsibilities amongst the PCFs in their firms, the central bank has no intention to be overly prescriptive in terms of the allocation of those prescribed responsibilities to specific role holders. So that approach will allow the firm itself to determine its own best way to allocate those responsibilities in a manner that will accommodate its own business model, its own organisational structures in line with its own governance. That makes sense to us and is in line with our view that we are not trying to change the business model of firms or a good governance structure. It's supportive and just to bring further clarity. It's right up front to acknowledge some debate occurred about the scope of SEER, particularly on the proposed inclusion of non-executive directors, including independent non-executive directors. And we gave that point very careful consideration. So we think it's important to recognise that non-executive directors have existing responsibilities under already existing corporate governance frameworks, including, for example, in respect of governance, oversight, challenge, strategy setting. And we consider that responsibility under SEER is fully consistent with those existing responsibilities. It does not impose increased obligations in that regard, and importantly, the standards to be met by these individuals in their role as a non-executive director will relate purely to their non-executive oversight functions and will, of course, be limited to what they should reasonably be expected to do in those circumstances. The SEER also introduces a duty of responsibility for individuals performing PCFs in the firms that are in scope to take reasonable steps to ensure that their area of responsibility conform to legislative and regulatory requirements, to provide clarity about what is expected in this context, and given that reasonable steps also apply in respect of conduct standards, we have provided guidance on the meaning of reasonable steps. In assessing the steps that an individual took, the central bank could consider what steps an individual in that position could reasonably be expected to take at that particular point in time. For example, it could include taking account of the fact that the individual is just a recent appointment to the role and that their overall level of experience in that context may be relevant. The common conduct standards will impose a single set of what we think are readily capable of being understood basic obligations on the individual carrying out control functions within a firm. We consider these standards to be straightforward, in line with what would be considered as good practice by individuals carrying out such functions. For individuals carrying out PCF or CF1 roles, a small number of additional conduct standards are imposed relating to the individual's responsibilities as a senior executive. You will find that the legislation itself sets out a range of helpful detail as to what is required under the different conduct standards. But once again, the concept of reasonable steps is at the heart of the conduct standards. The fitness and probity regime and the individual accountability framework can be thought of as two aspects of one overall framework of sound governance and accountability. Within the fitness and probity regime, if you think about that as being about the suitability of individuals, and if you think about the individual accountability framework being about clear responsibilities and ongoing conduct. So, for reasons of clarity, they can continue to be considered at a practical level in a separate way. That means the operation of the fitness and probity regime, including the gatekeeping function and the systems to place that support to the fitness and probity regime, will remain substantially unchanged. That's very important for firms to know that. There's a lot of interaction with the central bank in terms of gatekeeping approvals and the way that whole framework works. So, whilst the fitness and probity standards are relevant to assess an individual prior to their appointment, and of course on an ongoing basis while performing a specific role, the conduct standards only apply once the individual is in role. But central to successful implementation and driving a permanent uplift in governance standards, really the opportunity is for firms to take ownership of the frameworks. If firms embed the framework properly and fully, it should ideally result in fewer serious issues within their individual firms, within the sector over time, and from our own perspective, that would result in less enforcement actions. Enforcement is a critical component of our regulatory framework, but it is just one component. We use our enforcement powers sparingly, but we do take action where it's warranted. And I provide this context again to underscore an important point. The individual accountability framework, in our view, is about encouraging the good, not just focusing solely on stopping the bad. It's an opportunity. So following the receipt of feedback on the consultation paper, we intend to publish a related feedback statement and also to allow for an appropriate transitional period for firms and holding companies to implement the relevant changes introduced by the framework. So essentially the timeline will see the conduct standards applying from the 31st of December of this year. So operational from the beginning of next year. The fitness and probity regime certification, inclusion of holdcos, etc., to apply from the 31st of December of this year, and then the regulations to come into effect on the 1st of July of next year, which prescribe responsibilities of different roles and require in-scope firms to clearly set out allocation of those responsibilities and decision-making. I would really encourage firms to take ownership of this and to prepare the implementation of this framework by getting an early start, and many of you already have, on understanding your obligations, assessing your current governance structures, and taking the chance to make them as clear, as coherent, and as effective for your business as they can be. Firms will need to clearly define the roles and responsibilities of individuals and ensure clarity over reporting lines and any delegation of task. Firms should review their current fitness and probity processes to assess any enhancements required to meet the annual certification requirements, and firms should also examine their internal culture and values as compared to the IAF principles and identify areas of focus. Remember, it will not matter what kind of regulatory framework you prescribe, what kind of rules or obligations are written on a page. It is the lived values of the people who run firms who will deliver the effective outcomes, and that's the culture. Education and training will also play an important part in the success of this framework. So the framework also, the legislation in fact introduces changes to the central bank's enforcement process, and we will issue updated fitness and probity investigation regulations, fitness and probity investigation guidance once the underlying legal provisions have been brought into effect in the coming days. And the central bank intends to launch a separate public consultation on the detailed changes to the administrative sanctions procedure in the middle of this year. So the consultation package in that regard will include a consolidated end-to-end administrative sanctions procedure guidance and will comprise investigation, inquiry, settlement, sanctions guidance for consideration by all relevant stakeholders. That will be a significant consultation. I'm going to conclude here. I hope it's been useful in terms of framing our perspective, our aspirations for this, our desire to hear from you, and I hope our opportunity to clarify or debate some of the issues that you would like to raise. So I think I'll stop here, and I look forward to my colleagues having all the answers to your questions. Thank you for your time.
Thank you, Derville. And Derville will join us on the panel here. And just before we go into the Q&A session, I know the President of the Law Society has to leave for another engagement, so I'd just like to thank Maura for joining us here this morning. And we'll also introduce the other members of the panel. So obviously, as I said earlier, Derville will be joined by two of her central bank colleagues. So we have Gina Fitzgerald, who is the Head of Financial Risk and Governance Policy, and we also have Peter Gallagher, the Head of Enforcement Advisory. Two key aspects, clearly, of the process. Just a couple of logistics again about the Q&A session. I have one or two questions that occur to me myself. I might start the ball rolling, but I have my two colleagues, Deirdre and Chris, down the back, who have roving mics, to allow for everybody else in the hall to actually hear your question and hear adequately the answer. Please ask you to wait until you have a microphone in your hand, and I'll try and adjust each side to make sure that works as we go through. So please indicate your name and the organisation you represent before you ask the question, and we'll take it from there if that's okay. But maybe just to get the ball rolling, I might turn to you, Gina. I mean, the IAF framework, we've seemed to have talked about it for quite some time, but it's only one aspect of the central bank's role. Could you give us a sense of the bank's approach, I suppose, to the design of the framework, your expectations about its implementation, and also how it fits in with that overall regulatory approach?
Sure, thanks, Mark, and good morning, everyone. It's lovely to be here, although planning a dinner party in a parlour has its own appeals at this moment. So in terms of the objectives and the design of the individual accountability framework, obviously we've worked very closely with the Department of Finance in recent years in bringing this into being, and the ultimate aim being about improving governance and accountability across the financial sector. It's about establishing a framework of enhanced clarity, around responsibilities for individuals within firms through the SEER, but also these basic conduct standards of individuals across regulated firms. And I suppose the objective and the guiding principle across all our policy development and regulatory frameworks is about achieving better outcomes for consumers and users of financial services. So that kind of drives all our regulatory thinking. And our own draft regulations and guidance, which you'll have seen in the consultation paper which we recently launched, obviously they've been developed within the spirit and the constraints of the legislation that was published, but also we're very much guided by the central bank's own strategy and how we think about the development over the coming years of regulation and how that serves the financial system. So that's in relation to safeguarding the system, in relation to transforming in relation to how we can be future focused. And obviously in such a changing, quickly, rapidly developing environment, that's a key focus for us. And then finally, in terms of being open and engaged, when we think about these things, hearing your feedback, having this opportunity to provide clarity is really, really important to us. So this question of trust and confidence in the financial system is something that we come back to time and time again, I suppose, in terms of our thinking of how we develop regulatory frameworks and what it should be seeking to achieve. Just to touch very quickly on our approach, and I know Derville touched on many of these aspects, but just to say quickly, you know, we're very focused on ensuring that the benefits of any of our regulatory interventions outweigh the costs. And that's something we touch on in the CP in terms of that cost-benefit analysis. We appreciate there's going to be costs for firms as there are costs for the central bank in the development and implementation of this. And we don't take those lightly, but we think on balance there's going to be great benefit to the introduction of this regime. We're also very committed to proportionality in our consideration and our developments more broadly in terms of regulation, and specifically, hopefully you will have seen that in our approach in relation to this. Very conscious of the clarity of what we're trying to achieve, and again today hopefully we'll help to do that in relation to this specific framework, and then also reasonableness being at the heart of everything that we do. On the implementation question, I know Derville has touched on the timelines and how we think about seeing it come into being. But again, just to really emphasize the real opportunity, I think, at this stage in terms of working to achieve the clarity that we can, embedding it in the DNA of the firms that we regulate and that you service. And I think that there's a real opportunity for all of us to deliver something really positive for the Irish financial system, but also for the EU and international system that we regulate and are a part of.
Great. Thanks, Gina. I'm sure there are going to be lots of questions around elements of that as well. And I think, Derville, you touched earlier, right through your speech, on both the link between the policy and the enforcement. So I might turn to Peter for a minute just on that area of enforcement. The consultation paper explains just that one limb of the IAF framework is around changes to the central bank's enforcement process, but those changes aren't subject to this particular consultation, as Derville mentioned earlier. Could you elaborate on, where enforcement sits in the overall context of the framework, and when those changes will be subject to consultation?
Thanks very much, Mark, and again, thanks to the Law Society for working on this event with us. So the enforcement element of the overall framework is one of four limbs of the framework, as Derville outlined. We've got SEER, the conduct standards, the enhancements to the fitness and probity regime, and the enhancements to our enforcement framework. As you said, Mark, they're not specifically part of the current public consultation that launched in March. They involve significant enough procedural amendments to our administrative sanctions procedure. And really, those changes, which include additional safeguards in the process, are really based on the changes brought about by the IAF legislation itself, the emergence of recent case law, with which many will be familiar, but actually, most importantly of all, probably our considerable experience in operating our existing ASP framework over a considerable number of years. And so, in keeping with the bank's commitment to be open and engaged, a further consultation paper on those changes to our enforcement process is being finalised and will be launched in the middle of this year. But I can say a little bit about how enforcement sort of fits in with the overall framework. And I suppose on that, what I would say is that in common with all regulatory frameworks, enforcement operates as a necessary and appropriate underpinning of the framework. It's really about supporting the framework and supporting this IAF framework to be effective. And of course, breaches of SEER and the conduct standards will be enforceable, but actually we primarily see those things, SEER and the conduct standards, as drivers of positive change within firms. I think the other thing just to emphasise on the enforcement front is obviously that enforcement action is not something that we take lightly. And our overall approach to enforcement is not changing because of the IAF. As we've done in the past, we'll continue to prioritise enforcement action in a proportionate and targeted way, and that means that we will look at all the circumstances of a particular situation. We will consider the seriousness of the issues at play. We will consider the harm or potential harm that may be involved. And of course, we will consider the context arising in any particular sector of financial services. We'll also continue to think about whether our regulatory objectives can be met in a way other than by taking enforcement action, which is very important. And of course, we'll continue to be, and this is important, outcomes focused. And by that, what we mean is that we'll consider the outcome of the enforcement decisions, the overall outcome of the enforcement decisions that we take in the context of our overall regulatory strategy. And I suppose a final point for me, when we talk about enforcement, is it's worth taking it back to something Derville emphasised, and also Gina, in that SEER and the conduct standards are very much anchored in the concept of reasonableness, and there's a helpful level of detail in the guidance that's out for consultation at the moment around how we approach that concept and how we think about that concept of reasonableness, which of course ultimately will depend on the facts of any given scenario. But really, just to finish the question, Mark, I suppose the objective of the IAF is not about enforcement. Rather, the core objective of the introduction of this framework is about enhanced governance in firms. It's about better run firms. It's about clarity around roles and responsibilities, and it's about consistent standards of conduct and behaviour that are appropriate, and that ultimately will lead to better outcomes for firms, importantly, but also for consumers and for the users of financial services and for the sector as a whole.